Geþyncðo. Geþyncðo, also Geþyncðu, meaning Dignities, is the title given to an Old English legal tract on status and social mobility, probably written by Wulfstan Roman II, Archbishop of York, between 1002 and 1023. It is sometimes known as one of the so-called promotion laws, along with Norðlleoda laga, and both these texts belong to a legal compilation on status, dubbed the Geþyncðu group by the historian Patrick Wormald. Though the extent to which these reflect reality is a topic of some debate, they constitute one of the most valuable primary documents for an understanding of social status in late Anglo-Saxon England. The Geþyncðu group, manuscripts and texts. Taking the Geþyncðu group as a whole, Patrick Wormald distinguishes between two classes of manuscripts. The first originates in Worcester and consists of copies of texts in two of Wulfstan's autograph manuscripts, one Cambridge, CCC, MS 201D, which contains all 5 documents of the group: Geþyncðo, Norðlleoda laga, North People's Law, Merkna laga, Mercian Law, Athwith and Habit compensation for the ordained, and 2 co-ops 190 which preserves only the last 3. The second class was produced at a further remove from its original scriptorium. It is represented by 2 early 12th century manuscript families: the Textus Recensis, a substantial collection of Old English law texts with Latin translations, and B, the various manuscripts of the Quadripartitus, which offer a vast array of legal texts in Latin translation only. On grounds of style and layout, Wormald argues that the second class of the Geþyncðu group goes back to a common exemplar containing a southern redaction of material from Worcester. This material may have reached Rochester via Canterbury. Both Textus Recensis and Quadripartitus contain versions of Geþyncðu and Norðlleoda laga. As opposed to the law codes issued by Anglo-Saxon kings, the 5 texts offer no official enactments, but they record what the author or compiler understood to have been church law and customary law in certain regions of England, such as Wessex, West Mercia, the Danelaw in Northumbria. The core of the group is made up by a number of texts unworkled. Authorship and date. Since 1950, when Dorothy Bethume's study on the 5 documents of the group was published, the composition of Geþyncðu is usually attributed to Wulfstan Roman II, Archbishop of York, between 1002 and 1023, who was also responsible for drafting official law codes for Kings Hathord and Senapt. Wormald dates the text sometime between 1008 and 1014, when the Summerlupi ad Anglos appears to have been written. Contents. The introductory statement strikes a nostalgic chord about a golden age in which society was stratified by law and custom. Once it used to be that people and rights went by dignities, and councillors of the people were then entitled to honour, each according to his rank, whether noble or ceorl. What follows may well be the most famous line of the text, which lists the requirements of wealth and service by which once a ceorl could rise to thenhood. And if a ceorl prospered, that he possessed fully 5 hides of land of his own about and a castle gate, a seat and special office in the king's hall, then was he henceforth entitled to the rights of a then. The text goes on to distinguish between 4 different types of then and their qualifications. At the top stood the then who rode in the king's household band hired and had a mediant then to serve him and to represent him in court with the preliminary oath for oath. A less privileged type is the king's then who was without any such representative. On the next level is the mediant then, who likewise held 5 hides of his own, but served a king's then, attended him in the king's hall and was qualified to represent him with an oath. Finally, there was also a lower type of mediant then, who did not yet meet these requirements of land and service. The southern redaction in the Textus Recensis adds 2 further clauses. One is on the then who is promoted to earl ale and acquires the rights of an earl, and the other on the merchant who becomes a then by virtue of having made 3 voyages at his own cost. The next clause proceeds with the ecclesiastical component to social promotion. In a general way, it asserts that the scholar who distinguished himself through learning and took orders was entitled to more honour and protection, provided that he remained chaste. The final clause suggests that cases of physical and verbal violence against ecclesiastics and strangers were at all times to be heard at the royal or episcopal court, whoever the suspect might be.